I'm just leaving court. Let me show you the courthouse. There it is. It's our courthouse. This one's on the waterfront. You don't want to see the other areas around here. It's pretty messy. However, we went to court and opposing party thought, or opposing counsel, them as a team, thought that they could sandbag us with his new schedule, new job, disclosing it 6 days before trial. That's fine. I can always pivot in trial. So we pivot. He had this claim that, like, whatever fucking nonsense reason he thought he should get equal time sharing. I don't know. It was bullshit. It didn't make sense in the outro. And because I kind of obliterated them on their case before the trial happened, I kind of clued them into what they were arguing or arguing against. So he gets a new job, right? Well, he gets this new job, but it puts him in a worse position for parenting. So our original argument was parenting plan shouldn't be modified because it's just fine with your less than equal time sharing, sir. And then he propounds this new schedule, a new job that seems like it might have cured what we were arguing, except it made it worse. And then the judge ruled and gave him even less time. How are you going to bring your own case to modify, thinking you just have it in the bag that you'll get equal time sharing? Sandbag us with information. We didn't know your schedule until today in trial. And then I was able to make it like, oh, well, this schedule is even more untenable for the children. And for that reason, he should have weekend time only. Anyway, that's what got granted. He reduced his time. When our argument was just leave it the same, it actually got reduced. And that means his child support will go up. He wanted equal time just for the child support because he don't care about his kids. And he testified all up and down about how his new wife was going to be the one who was responsible for homework and schoolwork and some of the child's care. The judge wasn't having it. Anyway, don't try to sandbag me. I'll then use it against you. Okay, good morning, good morning. Today, we have a motion to compel. I have my attorney's fees affidavit all teed up because if you get found to not have complied with mandatory disclosure, then at that point, my motion to compel and the attorney's fees, which shall be granted, will be entitlement. And it actually has nothing to do with if you can pay them because it's a sanction for non-compliance. So today, I hope to have a court order for attorney's fees. Now, if I'll get them collected, let's have another conversation. We'll see. By the way, your stupid defense of, I didn't know, I wasn't sure, after I filed a motion, sent you a letter, had a phone call with you to compel you to be in compliance, is going to fail. And the idea of need and ability doesn't exist when the attorney's fees charged against you are as a sanction for your non-compliance of required provisions. Does that sound crazy? Well, what it really means is comply with the law. And if you don't know the law, get a lawyer. Because $1,800 says maybe you'll be compliant now that I've politely asked you to. Those are the attorney's fees I just got ordered this morning. Have a great day. Another week, another win. Actually, multiple wins this week. But I want to talk about the dad I represented, who was the primary parent of the child, and we went to mediation, and mom comes in, who has not had equal time sharing, even though it's the presumption, for years, and comes in and is like, I want equal time sharing, blah, blah, blah. Well, anyway, I speak to opposing counsel and I'm like, listen, this isn't what's been going on. Let's save this family thousands of dollars on a knockdown drag out and let's get it settled. So I want to thank even the mom in this case for being the more reasonable parent to take a real look at what her life and family looks like and knowing that the custody battle would have been worse. So again, my client got primary time sharing or more time sharing, more than equal, but mom did a great job on knowing that the custody battle would have been worse, would have been unreasonably expensive, and your children do not count overnights. They don't. It's the quality of your relationship, and without saying it and without knowing it, it's the reduction in conflict that the two of you can have. Think about it. Damn, in federal court, apparently, there's no video cameras. And I just gotta say, I'm dying to see this Diddy trial that's gonna come up this year. I've been listening to tons of podcasts and consuming a lot of material about it. And oh my God, I wanna see the Diddy trial. I wish it wasn't in federal court and that we could have cameras in the courtroom because it would be so good. I feel like each and every argument that could possibly be made to somehow show that the prosecutors are misstepping, they make. So juicy. You should have taken the deal. My client offered a very reasonable settlement for a trial that we recently got our trial order for. And the opposing party lost pretty hard, kind of a little harder than I was expecting. We got a better result than I could have predicted. Trial's unpredictable. It always is. But, if opposing counsel didn't immediately get fired because of that very bad result, I would have told them, you should have taken the deal, right? They thought I was lowballing them when turns out they would have gotten an astronomically better deal and not had the cost and expense of trial. And there's value in that, of course. My client was very reasonable and he was willing to settle for an amount of money that probably was a little high, but that's okay because he was going to avoid the attorney's fees and it was going to be over, right? It still took us 2 months to get a final judgment too, right? 2 days of trial. It was nonsense. There was no good reason for it to go this way. And he didn't have to pay me those attorney's fees, but he got his return on investment and it was pretty astronomical. So anyway, settle the case. I have another opposing counsel who should have taken that same advice this week. We have to go to a second mediation because they have to really come to terms with what was suggested by the guardian ad litem that we told them in the beginning would happen. I don't know. Take the deal when I offer it to you. You will not like the result if I have to push harder because I try to get my clients to be reasonable in settlement. Anyway, have a good day. And if my opposing counsel is watching this, we have a mediation this afternoon. Take the deal.